Hello, my name is Juana Juarez Rubio, and today I'll be presenting my first case analysis on Schwarck versus Articat Company. This case mainly explores product liability, negligence, and how tort law shapes business practices and high-risk industries such as Articat. So here's a quick overview of Articat Company, the plaintiff of this case. So the company was founded in 1960 in Minnesota by Edgar Hurton under the name of Polar Manufacturing, and it quickly became known for innovations in the snowmobile engineering. However, they faced major financial troubles and even filed for bankruptcy in 1981. But they made a fast comeback 9 years later, which is 1990, and they were able to earn over $138 million in sales and more than 12 million in. However, in around 2017, Textron Company bought Artica Company until 2025, and however it became independent again after being acquired by some private investors. So overall, the company has had a long history of growth, setbacks, and reinvention. So when looking at the financial performance, the data we have does show steady growth from 2010 to 2014. Arctic has saw an average increase of more than $700,000 in its sales and over $150,000 in gross profit, and a similar increase in their working capital. The revenue mainly come from snowmobiles, ATVs, side-by-sides, and related parts and accessories. Even though recent financial reports are limited, the long-term performance and partnerships suggest that it remained competitive in the powersports market. So how exactly did this lawsuit come to be? So the case arose after a tragic accident on McNeese Island. After a 2002 Arctic Cat 660 snowmobile went into reverse and broke through a wooden fence and fell off the west bluff, in which Karen Schwarck and her sister Edith Bono were both killed. As a result, the spouses sued Arctic Cat, claiming that the snowmobile was negligently designed, improperly tested, and had inadequate warnings. So the main argument of the plaintiff was that there was a silent reverse zone, meaning that there was a part of the reverse where the gear alarms didn't make any sound at all, which was crucial since Karen depended on that alarm to tell whether the snowmobile was going in forward or in reverse. So when there was no sound, she probably believed that she was in the correct gear. And to support this, the plaintiffs brought in a professional mechanic, which actually confirmed that there was a 2-inch stretch where the alarm simply just didn't go off. And actually, after the accident, the gear shift was found in that same spot where no sound was, or yeah, when no sound was produced. Along with that, there were also snow tracks that showed two separate stalls were made, meaning that she was probably making a 3-point turn, which showed that she wasn't being careless. She was actually trying to. So the court actually agreed with this high risk utility analysis. However, it found no economically feasible alternative design and dismissed the failure to warn claim because the snowmobile had already its proper warning labels. However, the Court of Appeals did say that there was enough evidence for a jury to consider negligence, so this case was allowed to continue on. As for the case impact, there's no evidence that Arctic Cat made direct changes because of the lawsuit, but in cases like this, usually it pushes manufacturers to constantly review their safety standards and improve their rider education, and they usually maintain stronger compliance practices. Along with that, lawsuits also increase legal and insurance costs. So I'm pretty sure Arctic Cat experienced some of that, even though it won. And in a more broadly way, tort law acts as a regulatory force, so it actually encourages companies to innovate responsibly while. So, in my opinion, the court made the right decision. However, the plaintiffs had every right to seek proper compensation, and they actually raised legitimate safety concerns. However, the law requires that it it shows proper proof of causation, which in this case there was none, and the evidence didn't show an actual design defect really that directly caused the accident. And since Karen Schwarck was an experienced rider, um, and the gear indicator, not the alarm, was the actual proper way to confirm if the gear was in reverse or in forward or in drive. And the alarm was never actually meant to indicate that, like the actual proper way. So the claim was denied. And so while the situation is tragic, the court ruling was based on the evidence, not on the actual emotion. And that's it. Thank you for listening. And this was a really sad yet interesting case to learn and write about.